This is an appeal in the matter of Phillips and ANR and Garraway and OI.
Good morning, my lord, my lady.
Hold on a second. Yes.
Good morning, my lords, my lady. I appear on behalf of the appellant. My learned friend, Mr. Doyle, appears on behalf of the respondent.
Yes.
My lord and my lady, this is an appeal that's been brought against the order, following the order of Her Honour Judge Venn on the 8th of January, dismissing Miss Garraway's appeal against District Judge Chambers' decision to grant possession of the Lodge, Southwood, Scarp Harbour Road, Hildenborough and Tunbridge on the basis that the respondents, Mr. and Mrs. Phillips, had terminated the tenancy following the service of a notice to quit dated the 27th of September 2023. The order for my lords and my ladies' notes are the order subject to the appeal is found in the core bundle at page 46, and her judgment, which I'll come to shortly, is at pages 47 to 55 in the bundle, tabs 5 and 6 respectively. The appeal raises the question, simple question, what is rent for the purposes of the Housing Act 1988? There is no statutory definition provided in the Act, so hence the reason why the courts are grappling with this question and this matter, having been granted permission to appeal, because of the issue that is raised and the impact that the decision will have on operation by the county courts in dealing with possession claims. The Housing Act 88, by way of just sort of brief overview, reduced the level of protection that was afforded to tenants in the private sector that were protected under the Rent Act 77. What it did in essence was remove the rent control that was provided to protect the levels of rent that could be charged to tenants, and reduced the level of security by introducing the assured tenancies and the assured shorthold tenancy regime. And the aim for the reduction, the removal of the rent control and the reduction in security was to make letting of private property an economic proposition, more economic proposition. So that was that in a sense is the backdrop to the Housing Act 88. In summary,
do we have anything in the authority bundle that gives us that context?
My lady, yes, there is. My learned friend refers to it in the supplementary bundle. It's the decision of in MacDonald and MacDonald at tab 3 of the supplementary bundle, and Lord Newberger, paragraph 11 to 15. At page 65 of the supplementary bundle, my lady will find there a helpful overview of the Housing Act, the progress through to the Housing Act 88 and the history. My lady will see at paragraph 14, reference quoting from the white paper, and the purpose for letting of private will again become an economic proposition. So, my lords, my lady, given the reduction in security and indeed the lifting of the rent controls, the position that is what's contended on behalf of the landlord, the respondents, is that when dealing with the question of rent and determining what protection there is and how, in what circumstances possession can be granted when the issue of rent is at the heart of the claim, what is contended by the respondents is that rent must be construed as pecuniary payment, i.e. payment of money, or if services do mount, i.e. provision of services in lieu of rent is to be equated with rent for the purposes of the Act, then it must be quantified by the parties in money terms. So the value of the service must be reflected within and agreed by the parties in the agreement. That's the position. I'll come to the judgment in a moment from Her Honour Judge Venn and indeed from District Judge Chambers. My submission is that rent is and includes payment in services and in kind, so money's worth, and does not have to be quantified. It is payment and must be payment because it is a sum that it's a service, or it's an alternative form of payment that can be quantified by the courts. It is one, it has a value, and two, the courts are routinely undertaking evidential assessments of what the position is between the parties, and indeed what the value of those in this instance, what the value of the services provided. I'll come back to how that can be quantified in a moment. But before I do, can I just take my lords and my lady to the judgment?
Just before you do that, I'd like to understand, if I can, a little bit more about why it matters. I thought, maybe I'm missing something, that if you are within the scope of the 1988 Act, then under the current law, about to be repealed, there is section 21, which enables a landlord to get possession simply by serving a notice anyway. So why does it matter?
Because, for example, there are circumstances when a section 21 notice can't be given. So, for example, if it is an assured shorthold tenancy and there is a requirement to serve how to rent guide, an EPC, an EP, if there's a deposit paid, the deposit has to be protected, and there's service of prescribed information. There are steps, there are provisions which prevent the service of the section 21 notice. So it doesn't follow that it matters not whether it's a notice to quit or a section 21 notice. There is a provision. And indeed, with the notice to quit, it's simply 28 days, and there's no right to as long as the notice to quit is valid, then there's no defence other than a public law defence, effectively, or something of that type. But my lord, so it doesn't follow that in a sense it's two horses running the same race at the same pace, neck and neck. It is a distinction which is there is, and which is an important matter to be dealt with. My lord.
Thank you.
Thank you, my lord. My lord, if I can take the court to the judgment, the relevant part in the judgment. The judgment is found at tab 6 of the bundle, and Her Honour Judge Venn deals with the arguments, and then at page 55 deals with her findings and her decision, and my lords will see that she is persuaded by Mr. Doyle's submissions that references to the amount of rent imply that the rent must be quantifiable or quantified in money terms. It's difficult to see how the services provided could be repaid. And then reference to the Schedule 2, which sets out the grounds on which possession can be obtained in context of rent arrears, grounds 8, 10 and 11. This formulation doesn't work where there's no quantification of the value of the rent. Mr. Doyle's submission to accept is that the law in relation to the Rent Act should be followed in relation to the tenancy. District Judge Chambers was right to find that the services provided were not rent within the meaning of the Act, and that the agreement falls within the exceptions of paragraph 3 or 3A, and accordingly tenancy terminated by the notice to quit, and then acknowledges in paragraph 41 how that finding and that adoption in terms of interpretation can be exploited by the unscrupulous landlord, which I'll come to in my closing submissions. My lord, District Judge Chambers' judgment can be found at tab 13, and at tab 13, page 120, paragraph 1. District Judge Chambers acknowledges that although you, in reference to Miss Garraway, although you have an obligation to carry out work, although that is an obligation which has value, although it is an obligation which someone has put a monetary value on it for tax purposes, it does not bring the case within the exception. It does bring this case within the exception to the protection provided by Housing Act 88. And then over on page 121, referring to paragraph 3, one of the exclusions to security under the 88 Act, it must mean no money is paid in rent, and I cannot see that there's any way allowing that the argument and the way around it is certainly not the sorrow I feel for your situation, because you have, as you have said, been doing your best. You've provided them with labour services. So the District Judge Chambers found that there had to be payment of money, pecuniary payment for the rent, and indeed that's been upheld by Her Honour Judge Venn. Before I get to take my lords and my lady through my submissions on what I submit is how the court should construe term rent in the Housing Act 88, can I take my lords to just two documents in the bundle in terms of chronology? The first is the agreement that was entered into, and that can be found in the supplementary bundle at tab 1, page 1. My lady will see that this is an agreement that was entered into by the parties on the 23rd of January 2023. It was for a 6-month rolling start from the 23rd of January. The rent, it was for notice of termination was 1 month given to both parties. Rent is defined as minimum of 2 days work on the estate, with hours from 9 o'clock in the morning to 5 o'clock in the evening, and the afternoon breaks to be agreed. My lords, if the one, before I carry on with the agreement, if I ask my lords to put the judicial finger at page 1 and go to page 137 in the core bundle, my lords will see there that it is the pleading. This is the pleading from on the claim for possession. Is that it is 2 weeks payable each week. About the tenancy, the current rent is £0, a minimum of 2 days work on the claimant's estate in lieu of monetary rent, and is payable each week. So that's the basis on which the claim and indeed the agreement was set up, namely that in lieu of payment for occupation of the property, there would be a minimum of 2 days working on the estate. My lords, going back to the supplementary bundle and the agreement, the agreement sets out that services, a number of services would be provided for the property, that payment would be made directly to the landlord for both the council tax, electricity, heating oil and telephone. Those payments would be made directly to the landlord based on the invoices that no doubt he would receive over time. That is it's a simple agreement, short agreement. That was the agreement that was completed, and Ms. Garraway took up occupation of the property and provided services. My lords, my lady will see that from the witness statement, and clearly there's issues in respect of one namely that there was agreement that it wouldn't be 2 full days but 4 half days, because Ms. Garraway is finding it difficult to work 2 full days, and that was agreed. And there's issues in respect to dogs and so on, which are not relevant for the purposes of the hearing and this appeal.
Does the agreement tell us anything about what kind of work?
It's work on the estate.
Well, I know, but that could
But-
be anything.
but it was the gardening. Working the gardening, that's the evidence of Miss Garraway. She found she was required to do gardening on the estate.
What is this estate?
I'm not entirely sure, my lord. I understand this is a house within the estate, and that's. But as far as the extent of the estate, that's not evidence in the sense that was before the court, what type of estate it was, or what. But this, I understand, this is a house owned by the Phillips, Mr. and Mrs. Phillips, who own the estate.
Yes. Well, I ask because if you're trying to quantify the value of the services that she's required to provide, that might depend on the kind of work which she's required to do, I suppose.
Well, there was no quantification at any stage, but in the evidence, and that's the reason why the court were not prepared to, in a sense, made the decision that was made was because it wasn't necessary, because rent didn't include services that were being provided. There was no money, and there was no requirement to pay money, and the agreement is not expressed as setting out what is the value of the services being.
Yes, but you said a minute ago that the value of the services could be quantified,
could be
even though they hadn't been.
Indeed.
Well, how can you quantify them unless you know what they are supposed to be?
Well, they would be quantified by the landlord, because he's required to submit returns each year on and the value that he receives for the services when he's completing his tax return. So that would be how he values it. How it can be valued is looking at how many days, minimum of 2 days. That's over between 9 o'clock and 5 o'clock, and using the minimum wage, and using the minimum wage 2 days a week over that length of time, over that period of time, times 4, gives you a value of over £600. So one can look at, could quantify the value of the services.
Well, you could say that it must be more than the minimum wage, simply by adding up the number of days, and therefore more than the £250. But if we're looking to put a value on services, it might be an agricultural estate, and somebody might be expected to do heavy manual labour, or as they become older and less fit, they might not be able to do that anymore. So they do less strenuous gardening tasks, for example. I'm just saying how if we're meant to quantify, or if somebody is meant to quantify this, how do they go about it without knowing the nature of the work which the tenant is agreeing to do?
Well, my lord, the court would, when the court is making a decision as to whether or not a tenancy is excluded by one of the paragraphs in Schedule 1, therefore not protected by the 88 Act, that involves an exercise of hearing evidence and evaluating and making a decision based on the evidence as to the value of the service that is being provided.
Just to interject, there is what I've seen is some limited evidence,
Yes.
not of what may or may not have been agreed in advance, but what your client was essentially asked to do, which on her evidence, as I understand it, was pruning and weeding land which had been neglected. So some form of heavy gardening work, and then there's a reference in her evidence to not being permitted to use powered machinery.
My lady's right. So in a sense, the evidence is limited as to in my submission, the court were following because of the submissions made on behalf of the landlord, that the court didn't need to carry out this exercise because rent could only be pecuniary payment as opposed to payment for money's worth, in money's worth. And given if the court, as they did, find that rent equals pecuniary payment, then it follows there's no need for the court to then embark on that exercise of assessing the value of the services that are provided. So, for example, hypothetically speaking, a vulnerable tenant in need of accommodation could be preyed upon by a landlord who waves the carrot, saying, "I can provide you with accommodation. Here are the keys, but you must work for me for 5 days or plus, and that you can live in this rent-free." Well, in my submission, the services that are being provided must amount to rent. Otherwise, if it's not, then this is the abuse that could follow if rent, for the purpose of the Housing Act, doesn't accord with rent at common law, which includes providing services, sheaves of corn, and going back to in history, right through to modern day. A person given accommodation to work in a car wash. My lords and my lady will have seen in the evidence that there was concern from the local authority that Miss Garraway was subjected to modern day slavery, and that was subsequently not. That went no further. But one can see, and this case highlights the abuse that is available, that would be available if the narrow construction of rent, as taken by both District Judge Chambers and Her Honour Judge Venn, is adopted as being the way in which courts are got to determine what is rent for the purpose of calculating exclusion from the 88 Act.
Can I just, this possibly goes back to the context of how the legislation works. To take my Lord's point, if you were to value these services at the minimum wage, you get to a certain number. Then that number may not be the correct valuation.
No,
it may be that the going rate, probably there is a going rate.
could be higher.
If you you make the assumption, let's say, that you know the type of services, maybe they're the kind that were in the witness statement. Is it necessary for the Act, in order for the Act to work properly, to go beyond valuing them, say, at the minimum wage?
My lady, valuation, my lady's quite right. The valuation for a particular job may be higher than the minimum wage. And that would be a matter of evidence for the court to determine.
And would there be a need to do that?
My lady, yes. The reason why is because if presented with a tenancy agreement which stipulates that the rent is services provided in lieu of rent, then the court must, in my submission, then accept that that is the rent that is paid, and then for the court to determine if the parties can't agree what the rent is, to carry out that assessment, to then decide if the tenancy is excluded from the Act because it falls within Schedule 1.
I think
Sorry, Melody,
the exclusion we're focusing on,
Yes,
the
sorry.
exclusion or exclusions at the moment that we're focusing on is no rent or that lower threshold,
Yes.
provided on a numerical basis you clear that lower threshold, which you would at the minimum wage. Does it matter beyond that
Beyond
what
that,
the
my lady,
precise value
yes,
is?
things stand at the present. A Section 21 note. If after that exercise the tenancy falls within the Housing Act 88, then the notice to quit doesn't have effect. It has to be the landlord has to serve a Section 21 notice. A Section 21 notice can't be served; it's prohibited if, for example, there is not provided energy performance certificate, or if a how to rent guide is not provided, or if there was a deposit taken within the tenancy, then that tenancy the deposit has to be protected, and there's prescribed information has to be served. So it doesn't follow that the exercise is an academic exercise. It's an exercise that is real, because first of all, the notice would be the wrong notice, so the court has no power to grant possession, because the claim is brought on the basis of the notice to quit. It's not a case of we've served both notice to quit and a Section 21 notice, and we're riding both horses, so to speak, and the court would then be able to say, well, we can't grant possession under the notice to quit because it's a valid tenancy under the Housing Act, and it's a shorthold tenancy, so therefore there's a Section 21 notice, and so there's ways in which a landlord could do it, but in this case the landlord hasn't. The landlord has just served the notice to quit and said, well, the notice to quit has expired, we're entitled to outright possession, and there's no court has no discretion.
I understand that, but following up what my lady was saying, and I think it was perhaps trying to broaden it, that there are presumably other provisions in the Act which require rent to be defined.
Yes, sorry, my lord. Yes.
So so that it's not simply a matter of you overcome a hurdle. There is rent.
Yes.
There are presumably a host of other provisions which require specific identification of rent for the purposes of other arrears,
yes,
etc.
My lord's quite right. I apologise if I haven't picked up my lady's point in terms of broadening. If it's a valid assured tenancy, possession can be obtained on basis of rent arrears, and grounds 8, 10 and 11 are the grounds on which possession can be obtained. Possession must be obtained where the landlord can satisfy one of the grounds in Schedule 2. Grounds 8, 10 and 11 deal with rent, and clearly there has to be a calculation of the rent. Ground 8, it requires 8 weeks rent my lords and my lady have the...
So these are some of the provisions that the circuit judge relied on.
She does.
I assume you'll take us...
Indeed, I was going to take
You're
it.
going to take us to them. Okay.
I will take you, my
Thank
lords and
you.
ladies, to that. So just to widen the point.
Yes.
But for the purposes of on the facts of this case, it is a narrow set of facts, namely there is only a notice to quit that has been served on the basis that this tenancy is out with the Housing Act 88, and the courts have found that it is on the basis that no rent was payable because there was no pecuniary payment, and indeed it wasn't quantified by the parties. So that's in a nutshell what the decision of the court was below. Before I move on, what I do submit is that District Judge Chambers did accept that the rent was quantifiable. I took my lords and my lady to where he in his judgment at paragraph 1. Where he talks about although you have an obligation, although the obligation has a value, although the obligation which someone has put a monetary value on it, so he accepts that the service provided by Miss Garraway was of value, because we know that rent must, under the common law, there must be profit. Indeed, and there is profit because there is a value in the service provided by Ms. Garraway, and that service is both a value, can be valued in monetary terms, and someone has calculated that for the purposes of for tax purposes. So what we have is that it's accepted by the judge at first instance that the rent that was required to be paid under the tenancy agreement was quantifiable, and there was a figure that could be paid. My lords, in the judgment...
You're not suggesting that whatever the landlord chose to put in their tax return was a figure which is binding on
Oh no, I'm not saying it's corroborative or it's supportive in terms of if the landlord gives a value. What we know from the definition of the rent under the agreement was a minimum of 2 days. It could be more. So
Yes, but when it says minimum, presumably no one's seriously arguing that your client could be forced to do more. So
No.
you might think that the commitment should be valued at 2 days.
2 days. The bottom line is 2 days.
As I understand it, your point about the tax is not that it's binding. But
No.
It proves
It's evidence.
that it must be capable of valuation.
It's capable of
Indeed,
valuation. But, well, given the landlord has valued it.
Yeah.
Whether that's accepted by the court as a true value is a matter for the court to determine. For example, it may be valued at £10. Well, the court would immediately say, well, actually, you've only valued for the tax purposes that the service has provided only £10, but there was 2 days' work.
Well, there's probably a range of figures at which the work could perfectly properly be valued.
Yes.
It would be in the landlord's interest to go to the bottom of the range, because then they pay less tax. It would be in your client's interest perhaps to go to the top of the range, because then she's providing more value.
But the what I would submit is that what it shows is that it is capable, that it is open to the court. The court is able to value the service that's being provided under the tenancy. And we can see that the basis for District Judge Chambers' conclusions in his judgment, paragraph 1, we can find those at page 55 of the supplemental bundle. This is the transcript of the actual hearing. Page 55, Garraway states, my labour, which is worth something, and he replies yes, and goes on, it may be worth something, I suspect it be worth quite a lot, but that doesn't answer the question whether any rent is payable. And what Mr. Griffin, who's counsel for the landlords, is saying is that if it's payable, it has to be payable in monetary terms. We can't take away your labour from you, and put it in a bag and hand it over. So it's not payable. You have an obligation to work, but it's not an obligation to pay. Over page 56, just above D, letter D, Ms. Garraway says, but what about my labour? It has a monetary value. Mr. District Judge Chambers, it does, but we don't know what it is. Well, you know, I'm for the work I was doing. I can certainly, and she goes on, it can be estimated. And at the bottom of the page, they were hours, so a day becomes, you know, so many hours, so you can calculate it at an hourly rate. Judge Chambers, yes, but it's still not money. Over the page at 57, it still has an accountable. It still has to be accountable under, I believe, for tax reasons. I think in this case, you know, there has to be accountability for how much the landlord has gained from, and Judge Chambers, but it's not payable. And what this is what Mr. Griffin is arguing. It has to be payable, and payable, he says, means handing over cash or credit or something similar. It can't mean doing some work for somebody. It has to mean handing something over. And she replies, I handed over my labour, sweat equity. So those are relevant exchanges showing what was being said by Ms. Garraway, who was acting in person at that hearing. My lords, my lady, there's no dispute between the parties that at common law, rent doesn't have to be paid in money. The only requirement is that there is profit to the landlord. And indeed, I've cited relevant paragraph from Woodfall at paragraph 7004 at paragraph 15 of my skeleton argument, and which clearly shows that the common law's position, the position of common law is that rent can take the form of services as well as payment in kind through provision of produce or indeed animals or arable produce. So at common law, rent can be in kind, in money's worth. That is reflected in the Law of Property Act in section 205, subsection 1, Roman numeral 23. My lords will have that in the authorities bundle at page 178. So for dealing with the leaseholds and payment of rent, if one goes to page 178 at Roman numeral 23, rent includes a rent service or rent charge or other rent, toll duty, royalty, or annual or periodical payment in money or money's worth. So rent isn't pure pecuniary payments. The Protection from Eviction Act also provides that.
It is payment.
Sorry,
It's payment.
indeed, payment in money's worth.
Yes.
And payment in money's worth must mean where you're obliged to provide services but not receive payment for those services, but those services are taken as in lieu of the rent. So one balances off against the other liability, and in a sense, as set out in this agreement, short-circuited. So there's no quantification of the services. It's just simply you have the right to occupy the premises, and in payment, the rent is the services that you provide, which will be taken as in lieu of payment, which is the position here. The fact that services can and are to be included when defining what is rent is supported by the position in the Rent Act, the Protection from Eviction Act 1977.
Can I just go back to Woodfall? Sorry to take you off, because we have 7004.
Yes.
And it refers to rent may also take the form of services. Thus, the rent may consist of cleaning a church, synagogue, performing teamwork with horse and cart. I just wonder whether anybody's looked at those to see the form they take.
My lord, I'm going to take your lordship to there's three decisions.
Okay.
And
which go back to
and in particular reference to the synagogue.
I remember that. Well, yes, I know. But
synagogue.
Yes,
that's Montague.
Yes,
and then there's Barrett.
But it's quite easy to look at the generalisation. But I wondered actually whether, when you looked at the authorities, whether they had something more specific.
The Montague, the cleaning of the synagogue.
Yes, but the answer is
I haven't got the.
We haven't gone through the old back. What's the oldest?
They go
the
back
oldest one here goes back to 1823.
Indeed, and my lord will see that Woodfall is cited in these authorities as if, in the sense that this is trite law.
Yes.
And it's the starting point.
Okay.
And Woodfall says therefore that must be right.
You're suggesting not too much archaeology.
Yeah, no, it doesn't encourage it.
Okay.
Lord, but
sorry, thank you.
No, my lord, but we certainly will pick up the detail in terms of the synagogue and the payment of services.
Right.
In the decision of Montague.
So you were taking us the Protection from Eviction.
The Protection from Eviction Act, my lord, yes. Which can be found in the bundle at tab 14, page 185. Protection from Eviction Act applies in respect of any premises let as a dwelling, looking at section 3.1. let as a dwelling under a tenancy, which is neither a statutorily protected tenancy nor an excluded tenancy, and the tenancy has come to an end, but the occupier remains in occupation, it is not unlawful for the to enforce against it otherwise than by proceedings in court his right to recover possession of the premises. So this is in a sense the protection that's afforded to all tenants,
Yes.
except those that are excluded or statutorily protected tenancy or excluded tenancies. And an excluded tenancy is defined in section 3A. So if it's an excluded tenancy, then you don't the landlord doesn't have to go to court to obtain possession. He can do peaceful re-entry and so on. He can doesn't have to get a court order. And in section 3A, it's headed on page 187 over to 188. There are a number of tenancies or licenses that are excluded from the protection from the Eviction Act 77. And in subsection 7, a tenancy or a license is excluded if, little b, grants otherwise than for money or money's worth. So a tenancy that doesn't require payment of money or money's worth is an excluded tenancy or license, and therefore there is no bar to obtaining possession only with a court order, and therefore the landlord doesn't have. It's effectively the tenant has as little protection from eviction.
Does that help you, or is it against you, in the sense that it's defining, not by reference to rent, but just saying it's granted otherwise than for money or money's worth? So it
yes,
it could be said to be broader.
It's a tenancy that's been granted for money's worth.
Yes.
Would fall within the protection.
But are you saying this tenancy would be for money's worth?
Yes.
Right. So what I'm asking you is that does the fact that in the Protection from Eviction Act is defined in, or to be a tenancy, to be within its scope, to be excluded otherwise than for money or money's worth. So the inclusion of the words or money's worth, broader, might be against your argument for the meaning of rent in the Rent Acts and the Housing Act, rather.
As I would read subsection 7.
Yes.
A tenancy for money's worth is not excluded.
No.
But that explains why you're here, in a sense. It doesn't.
So that what's required is a notice to quit. But what I'm saying for the purposes of the Housing Act, money's worth rent must be both money, payment of money, and money's worth. So because there's no definition for rent in the Housing Act 88, and there must, in my submission, be there has to be some form of payment. Payment in the looser sense.
Yes.
There must be profit. Sorry, not payment. There must be a profit to the landlord. So, in the instance of payment through providing agricultural produce or animals to the landlord, there's a profit in that. And the profit in this instance, a more modern and as acknowledged rental agreements in today's climate is generally payment of money. But it doesn't mean that you can't have payment through services or payment through alternative means. So payment by giving a watch or something, some sort of tangible object that would amount to a payment in money's worth, which would, I say, fall within the definition of rent, and therefore, because it can be valued, and therefore it can be protected by the Housing Act.
But this section 5 only applies if the tenancy is not otherwise a statutorily protected tenancy.
Yes.
So it only applies if you weren't protected a statutorily protected tenancy under the Rent Acts or under the Housing Act. So we're outside
Of that act.
of that act. And Parliament decided to include within the scope of this act tenancies in respect of which were granted for money's worth.
Money or money's worth, yes. Yes. So so for the purposes of the Housing Act 88, because it must also include rent for money's worth.
Yes, but so exactly. So your argument is money's worth brings you within, makes you a statutorily protected tenancy.
Yes. Yes. So
when would this apply? When would a tenancy is excluded if it's granted otherwise than for? So
if there was no payment.
no, I understand that, but what is this getting at? Do you see what I mean? On your submission, this form of tenancy for money's worth is a statutorily protected tenancy.
Yes.
So you don't need the protection of the Protection from Eviction Act because you're already protected. So what type of tenancies is this act getting at that are outside the scope of of otherwise being statutorily protected? That's what I'm asking you.
The way that the court below have approached it is that because the money's worth is excluded from the definition of rent, it falls to the protection.
You are within this, exactly. So that would be an example of where the Housing Act, Rent Acts don't apply, but this Act does.
Yes.
Are there others
No,
that you can give us?
That is.
Really?
As far as that, from my experience and understanding, that's the protection. So if you have no statutory protection,
Yes.
then the Protection from Eviction Act is got a broader brush and includes money or money's worth. But what I say is that following in line with common law, the approach of common law, where services can be rent, then one doesn't get to where services are paid and have a value, money's worth. Then the
Yes, no,
Housing Act
don't worry, I
is-
understand that. What I'm trying to make sure is we're not talking at cross purposes. What I'm trying to identify is what tenancies was this Act trying to protect, which were otherwise outside the scope of the Rent Acts or the Housing Act. And if it's only money's worth, then that would seem to be against your submissions.
My lord, at the time it would have been the Rent Act 77 that would
Yes.
have been in force,
Yes.
and the Rent Act 77 provided security for protected tenancies, and then on the expiry of the protected tenancy became a statutory tenancy.
Yes.
And there were specific grounds on which possession could be obtained. So if you weren't a protected tenant or a statutory tenant by following on, then the Protection from Eviction Act would engage. So what I say is that given that rent is not defined in the Housing Act, and given that the approach of the court has been consistent in that rent can include in payment in lieu of services in lieu of payment for the rent, that it must mean that where the agreement specifically provides that work is provided in lieu of payment, a monetary payment, that is rent for the purposes of the Housing Act, and so money's worth is covered and falls within the Housing Act 88. And we don't have to rely upon the 77 Act. And it goes back to the point my lord made at the very outset. What's the point? What's the difference between a Section 21 provision, a notice, and possession being sought, and a notice to quit. And the answer is there is a greater protection afforded to an assured shorthold tenant than there is to a tenant who's served a notice to quit and has no right to oppose possession, because the courts are bound to give possession because the tenancy's come to an end and there's no
So,
statutory
so under the
protection.
1977 Act, the protection you get is that the landlord has to get a court order,
Yes,
but provided they have given a notice to quit,
it's
they
gone.
will get the court order because they don't have any other protected, the tenant doesn't have any other protected status.
That's right.
And then to actually get possession, is all they need the court order, and then they can re-enter themselves, or do they have to
They
get the
can,
bail?
they can go for a warrant and seek to execute the warrant to get the bailiffs to come in and force.
Do they have to do it through the bailiffs? They can't
Yes, through the
simply
bailiffs.
do it themselves once they've
Well,
got
they can do peaceful re-entry, or they could do re-entry, but that's fraught. Generally speaking, landlords rely on the bailiffs to do to do that, as opposed to themselves. But yes, technically they could. So, my lord, can I take my lords, my lady, unless there are any further questions, to actually the statutory scheme itself that we're concerned with? That's the Housing Act 88. Can be the relevant sections can be found in tab 15. My lords and my lady will find that the tenancy following the Act coming into force, any tenancy let as a separate dwelling for the purpose of the Act is an assured tenancy if so long as this is page 193. The tenant or joint tenant is an individual. The tenant, or as the case joint one, occupies the dwelling house as his only principal home, and the tenancy is not one which, by virtue of subsection 2 or subsection 6, cannot be an assured tenancy. So, if we look to subsection 2, subject to subsection 3, if and so long as the tenancy falls within any paragraph within Part 1 of Schedule 1 to this Act, it cannot be an assured tenancy. And my lord and my lady, the Schedule 1 then sets out a range of situations where a tenancy that has been granted cannot be an assured tenancy, and there are varieties. For example, a holiday let, agricultural tenancy, business tenancy, and so on and so forth. There are 22 different paragraphs. If one goes to the schedule itself, sorry, Laura. The relevant paragraph that that my lords and my lady are concerned with, if I can pick it up, paragraph 2.
Sorry, which Schedule 1?
Paragraph 2 of Schedule 1,
Right.
page 220 in the bundle. And paragraph 2 deals with high rent. So a tenancy entered into on after the 1st of April, under which the rent payable for the time being is payable at a rate of exceeding £100,000 a year. Rent, important, can I just draw the court's attention to subparagraph 2. Rent, is relevant in the sense it applies to paragraph 3 and 3A in a moment. Rent does not include any sum payable by the tenant, as is expressed in whatever terms to be payable in respect of rates, council tax, services, management, etc., unless it could have been regarded by the parties. Could not have been regarded by the parties to the tenancy as a sum so payable. So those additional payments, being rates, services, etc., do not include and are not to be included in assessing what is rent, unless it could not have been regarded by the parties to the tenancy as a sum so payable. I would submit that where the parties agree that those sums are in part payment of the rent that is due to be paid for the benefit of exclusive occupation of the property, then those sums are to be included. The reason that's relevant will become obvious in a minute, because when it goes to paragraph 3.
Is that talking about sums payable by the tenant for things including services provided by the landlord?
Yes. It's not to be included unless the parties agree. When one looks at the tenancy agreement,
So it's not talking about services provided by the tenant in lieu of money.
Maybe I need to make good the point by reference to the document. If one looks at the tenancy agreement at page 1 in the supplementary bundle, it specifies
Yes, the tenant is invoiced for things like council tax, etc., and that doesn't count as rent.
What's agreed is that those payments will be paid monthly to the landlord. I'll come to the case in a moment, but I say where that landlord is charging, then and is recovering payments, for example, electric rates and so on and so forth, then that is to be construed as part of the payment of rent. So in this case, I would submit in the alternative that not only is the services provided in lieu of rent by Ms. Garraway rent, but also the payments that were required to be made for the services that for electric and so on, demanded by the landlord on the basis of the monthly payments to be made based on the invoices that he received.
So to be clear, you say, well, while in paragraph 2 there's a specific provision saying that rent doesn't include
Yes.
payment for things like council tax. I think you're saying, and I think this may be a new argument.
It's part of what is the rent. Sorry, apologies.
You're saying that there is no equivalent provision in paragraph 3 or 3A. Is that the point?
My lady, yes. Can I go to 3 and 3A so you can see where to make the point?
Oh, this is a new point, not within your grounds of appeal, isn't it?
No, because it's within the definition of what is rent. I say that it is rent, both payment of service, the payment of through services of what is provided, and also through payment of it's a matter of construction of the agreement. One can see, if I can take the court to page 225 of the bundle, paragraph 3C, which I know we haven't looked at paragraphs 3 and 3A and B at the moment, but my lady will see paragraph 2B, 2.2, which is the paragraph that took.
Right, so I was wrong in what I just said, because 2.2 does apply.
Does apply for the purposes of assessing whether there's any rent paid or it's low rent.
So
So
you'll have to. Okay, then I haven't understood your submission.
apologies. What I say under the agreement, firstly, that the rent that is due is services, the work that is being provided on the estate. That is the rent. But also, in addition to the services provided, rent includes the payments that are demanded for council tax, electricity, heating oil, etc.
But isn't that the opposite of what 2.2 says?
But 2.2 says, my reading of my submission on 2.2 is that unless it would not have been regarded by the parties to the tenancy as a sum so payable. So the last part of the sentence, it provides it's a double negative, as I read it, which means that where the parties agree that that sum is due, then it would be so payable, namely as rent.
Picking up what my lord said, I didn't see this featured. Does it appear in your submissions to the judge below or the district? And I'm not sure it features in the defence.
Or in your skeleton argument for this appeal.
Well, it's in the supplementary submission.
Did you
and
raise
it's-
it,
it's-
first
it-
of all, did you raise it below?
No, it wasn't raised below.
Right.
Um,
Okay. Hold on. And you rely on your supplementary
my lord, I think it's also
skeleton paragraph 4.
my lord, paragraph 24 of my skeleton.
Yes.
And it's the case of Sydney Trading and Finsbury Borough Council.
Okay, we'll come to that in a moment.
And that's
But
this
you-
is the point that I'm taking.
The submission you're advancing is that the way in which the agreement was structured is such that the sums payable in respect of rates, etc., could not have been regarded by the parties to the tenancy as a sum payable in respect of rates, etc.,
It would be part of the payment.
even though it expressly states they're in respect of rates, etc.
My lord, yes.
So it's quite. It seems to me quite a difficult argument to mount in any event when the agreement expressly says, "But you're going to take us to Sydney Trading in support of your submission."
Yes.
Okay. But that's the submission you're seeking to advance, and I think you're acknowledging that it is a new argument.
I'm acknowledging it's a new argument. No, it's an argument that I didn't advance in front of her on the Judge Vet.
Okay.
But it is an argument that's consistent with, in my sense, both the construction of the agreement and also the submission and the operation of the statutory scheme, because that's what the court is considering. My lord, the decision of Sydney Harbour.
Just going back to 2.2.
My lord, yes.
It's expressly excluding, subject to the exception, sums payable by the tenant, expressed to be payable in respect of. So again, it's sums, or a sum, as we say, any sum.
Yes.
So again, it is
Reference to
payment. Yes.
Pecuniary payment.
Yes.
My lord, what I say is my primary submission is that services provided in lieu of payment of the rent is.
Don't worry, I understand that. I'm just trying to work out.
Separate to this point.
I'm just trying to work out whether this has any impact on that, because it is simply excluding certain sums, unless they could not be regarded as being payable in respect of those items. Okay, thank you. Yes. So the authorities.
Yes. It's at tab 3. It's the decision of.
Now, can I just stop for a second? You said you were going to take us to other provisions, I think, in the Housing Act. You're going to come in with that later?
Come back to that.
Okay.
This is because it's just to finish this point.
Right. Thank you.
And this what the one can Queen's Bench Division 1952 and in that case the landlord the tenancy the rent to be paid under the tenancy was £5 and 4 shillings. Clause 3 of the agreement, the tenant agreed to pay the landlord for transmission to the appropriate authorities all existing future general and water rates. And the question for the court was whether or not those payments amounted to rent for the purposes of the 1920 Act, and the court held that the rent did include those sums. And Lord Goddard, Lord Chief Justice, gave what is a short judgment at page 48 and 49 of the bundle, and the question being whether or not the money that has to be paid to the landlord for rates is part of the rent for the purposes of the Act, and the conclusion, my lords will see at page 462 at C, position. So
Sorry, what I'm at, I'm afraid, before that, 461's G, referring to two previous authorities from 1948 and 1949,
Lord,
seem to me to lay down clearly that the test for deciding what is rent for the purpose of the Rent Restriction Acts is to ask what is the total monetary payment to be made by the tenant to the landlord. So that was the sort of established approach. Sorry, and you were going on to 462 where?
42 462A,
Yes.
top of the page.
So in applying that established interpretation, it was decided that it matters not whether the payment is for rates, services or furniture. If there is a sum of money which the tenant agrees to pay as a consideration, it is for this purpose a rent. Now that was dealing with a different provision.
Yes.
And do you know where the provision in paragraph 2.2, was there a similar provision in previous legislation? Do you happen to know?
My lord, I don't have that. I can certainly provide the court with that after this hearing today.
Because on one view, it might seem that provision, this might be stretching it a bit, was included to address this. That no, it's not included within rent if it's payment for rates, services, etc., unless it could not be construed as being payment for rent services. You see, I mean here, because
yes, I can see my lord's point. I need to check go back into the 19.
I mean, speaking for myself, I'm not sure that Sydney really helps you because it's dealing with a different provision that had an established interpretation.
My lord, I'm not going to. My primary submission, which my lords and my lady know what it is in respect to services being rent.
Yes.
Is in a sense not affected by this. I just
Okay.
raised it in a sense because a matter of statutory construction, trying to consider, because when we look at paragraph 3, if I can go back, apologies, if I can jump back to the schedule 1,
Yes.
we can see paragraph 3 is at page 222 of the bundle, the authorities bundle.
Yes.
Tenancy can't be assured, where a tenancy under which, for the time being, no rent is payable. And then under 3A, where the rent payable for the time being is payable at a rate of, and then gives you the two values.
Yes.
In London and outside, £250 outside.
Yes.
And then paragraph 3B, tenancies are excluded from the 88 Act, where the rent for the time being is less than 2/3 of the rateable value of the house on the 31st of March 1990.
Yep.
So, and then the reason I took my lords and my ladies to paragraph 2.2 is because then 3C then engages 2.2 for the
Yes.
purpose of assessing those
Thank you.
values.
Yep.
My lords, the position is that those the court are then required to assess whether or not a under para 3 or 3A, which is relevant in this case, no rent is payable, and whether the rent that is payable is less than the value, in this case £250. So, and my submission when interpreting the question of what rent is payable, it's not limited purely to pecuniary payment, money. My Lord asked earlier on about the position in respect of possession proceedings, and if I can take my Lord to ground 2, which sets out, or sorry, Schedule 2, which sets out the grounds against which possession can be obtained where there is an assured tenancy and a landlord serves what's noticed under Section 8 requiring possession. And my Lord will see at page 284 the relevant grounds.
Sorry, which page?
Page 284.
Thank you.
Apologies, that's the wrong reference.
Is it ground?
Ground 8.
Page 270.
Thank you.
Ground 8. So this is a mandatory ground where rent is, if rent is payable for at least 8 weeks and it's unpaid, or 2 months unpaid, etc. If that ground is satisfied, then the court is required and is bound to grant an order for possession. But there is a discretionary grounds, and grounds 10 and 11. So where the landlord relies on, for example, arrears and persistent delay, but can't satisfy ground 8, he may be able to convince the court to exercise its discretion to give possession because the tenant has persistently failed to pay the rent that is due, lawfully due. My lords, the
One thing the court might do is make an order for arrears of rent to be paid. How does that work in this case?
there would be no, there is no, they wouldn't be able to enter a money judgment because there is the payment, there's been no valuation up until the point of the court hearing. So where the parties haven't agreed as to the level of the arrears, then the court would, the court would have to work out.
Well, take ground 8. If rent is payable weekly, at least 8 weeks' rent is unpaid. Well, that's 16 days worth of work. Does the court order your client to do 16 days worth of work?
It can't give an injunction to require, to compel.
And it can't.
It could order possession.
It can order possession, but it can't order work to be done, and it can't translate the work that hasn't been done into money, can it?
Well, if there's a claim for money judgment, there's a breach of contract, and the value is placed on the breach of contract, namely failure to provide the service, and it's equated at X pounds, then I can't see why the court wouldn't be able to make an order saying there's a breach of contract, because in essence that's what it is. It's a breach of contract and a failure to provide the service. So yes, but then that would require the landlord to put the value on the breach of the contract, and the consideration that's not been provided in the work that's not been undertaken would have to be valued by the landlord in order to obtain the money for breach of contract.
Ultimately by the court, you would say.
Ultimately, indeed, everything is down to the judge on hearing the facts to determine whether or not to order order damages. Because at the end of the day, that is what any money judgment in a tenancy, a claim for possession is. You get possession, and then there is a money judgment for breach of contract, failure to pay the rent that's due under the contract. So there should be no difference in that the court can assess the level of damage to be awarded. So it could find that having made the inquiries and heard evidence, come to a conclusion as to the level of the breach, the value of the rent in terms of monetary terms given the breach, and then determine possession and a claim for damages following.
I take it that is your answer to because the circuit judge referred to these provisions.
Yes.
And if I recall correctly, essentially said that they couldn't see how they
Indeed.
would work.
This
is your response.
This is my response to that. It can work because it's the same, whether it be a claim for possession based on the failure to pay the £100 a week, calculated to being 8 weeks, £800, and damages for use in occupation pending following the decision, and the same for the court to assess the value of the breach for failure to provide the works, which were services in lieu of rent payment. So they would still be entitled to possession if the value of the work is calculated at being over the ground 8th level, and in those circumstances, order for possession and damages for breach of contract for failure to provide the services. That's the route in my submission.
And you say the same, do you, if for some reason, leaving aside the impact of the word minimum, your client has overworked?
Yes, because if she
back the overpayment, that would be translated into the value of gardening services in that area at that time, or something like that.
If the the way the agreement's structured is that a minimum of 2 days school.
Well, that's why I said leave aside the impact of minimum, which is a point taken against you.
Yes. But the whether it be 2 days plus, it is possible for the court to determine what is the value of the breach, and and having calculated the value of the breach, then it can determine whether the ground, if Section 8 is relied upon, whether possession is entitled, or if a Section 21 notice is served, then there would still be entitlement to damages based on the calculation. My Lord, I appreciate I've taken a fair bit of time here. My Lord, can I take to two authorities? I said I would take to the
Yes.
To the two authorities that deal with have addressed this issue. The first is the case of Montague and Brining at tab 4. This is the synagogue case, my lord. This is the case where the tenant was employed as the caretaker, but he was also allowed to occupy the house, and whether or not that fell within the same provisions as to what one is this court's considering today. What was agreed between the synagogue, the trustees of the synagogue, and the defendant was that he would his work that he carried out would be knocked off against the rent, and he would have to pay as a result 10 shillings as opposed to the true value of the rental for the property. Then his wages were increased, and thereafter, because his wages were increased by that 10 shillings, he didn't make any payment. Then the trustees then sought to recover possession of the property, and it was argued that he was protected tenancy by virtue of the original agreement, not as and therefore they weren't entitled to recover possession. The judgment, the Court of Appeal judgment was given by Lord Justice Singleton, and a short judgment then given by Lord Justice Denning, Lord Justice Denning, and then Lord Justice Morris. My lords, in Lord Justice Singleton's judgment, if I could take my lords to it's at page 1043. It's reported in 1954 at One Weekly Law Reports, and my lords, if I could take lordships to page, as I say, 1043, and the paragraph before the Rent Acts came into operation, my lords, if the lords could read that, the start of that paragraph.
Yes.
And then the minutes, further on, the next paragraph, minutes show that there was an increase. The rent wages had to be paid in some way, probably a saving to the officials of the synagogue not to have made cross entries. Then the County Court was inclined to decide the case in favour of the tenants, and then he was referred to the case of Hornsby and Maynard, which is a divisional court decision reported back in 1924. Apologies, in my skeleton argument, I have put that referred to that case as being the decision of the Court of Appeal. It's actually the divisional court decision, my lord, and then cites the judgment of Mr. Justice Shearman and Mr. Justice Slater. If my lords could read, starting at the top of page 100, page 100, 1044, please.
Yes.
My lord will see then, the Lord Justice continues, I think that it may be necessary at some time for those words of Slater J and some words of Shearman J to the like effect to be reconsidered. I don't think the decision of the court, divisional court in Hornsby and Maynard affects the present case to any degree because of the facts. And then if one goes to the judgment of Lord Justice Denning, and my lord, if my lord's short judgment, 2 paragraphs, could I ask the court to read that, please?
Yes.
And then, my lord, finally, Lord Justice Morris, just at the bottom, starting, I do not think.
Yes.
So, my lords, the facts on that case were that the services were being provided for the cleaning of the synagogue, and the tenants were protected. The draw out the clearly the Court of Appeal were unhappy with the decision in Hornsby and Maynard, but that divisional court decision didn't affect the outcome of this case. But Lord Justice Denning does acknowledge that, I mean, all three judges accepted that the matter of whether rent in payment in services in lieu of money was rent, and Lord Justice Denning seems to me that even under the Rent Acts, in cases where rent is not payable in money but in kind, as in goods or services, then so long as the parties have by agreement quantified the value in terms of money, the sum so quantified is rent of the house within the meaning of the Rent Restriction Act, and if exceeds 2/3 of the houses within the Acts. He goes on, I say nothing about the position where the services are not quantified in money, except to say that even on that point, some of the observations in the case may need to be reconsidered. So, where the landlord and the tenant have agreed to for this rent to be paid in by way of services in lieu of payment, even where those services haven't been calculated, then the approach clearly, in my submission, the approach should be that those services which can be calculated should be calculated by the court to determine the extent to which protection of the 88 Act is afforded to the tenant. What is to be noted?
Well, that's your submission, but it's a bit hard to get that out of this case, isn't it? Lord Justice Singleton and Lord Justice Morris decide the case on the basis that the original agreement was included payment of rent, and there was a money sum payable, so that was quite straightforward. And as a finding of fact, they say the change in the way it was going to be dealt with from whatever the date was didn't change the character of the Lord Justice Denning, not for the first or last time, puts his judgment on a different basis from the other two, and says, well, you can, if you have by agreement quantified the value in terms of money, that's good enough. But that's as far as he goes, and that falls short of the facts here.
It falls short, I accept, my lord, it falls short of fact. What it, there is, can I take my lord to the next case, and then I'll make my submissions. And the next case is in the next tab, and it's the case of Barnes and Barrett, which is a decision of the court, this court, in 1970, 2 Green Bench at 657. And the facts of that case are important, namely that the tenant of the house had an arrangement with the defendants that they would get exclusive use of the 3 rooms and the kitchen, and the tenant had 2 rooms, and then the bathroom they shared. And in return for this arrangement, the defendants were to clean the rooms, the shop, cook for them, and pay the electric, gas, etc. So effectively, looking after the tenant. Tenant then dies, and the landlord seeks to recover possession. And the judge held that the defendants were tenants of the rooms protected by the Rent Act 87 because of the services provided. They allowed the appeal. Term of rent in the Rent Act denoted rent in money only, and that as the rendering of services of the tenant had never been monetarily quantified, those services could not constitute rent within the Act. However, given the facts of the case, the tenancy was not a tenancy, it was a mere personal license to occupy the accommodation. And that is the decision of the court on the facts. This was not a license, this was not a tenancy, it was a license. But the court then did consider the question of whether or not it was whether or not rent was paid on the basis of whether there was a tenancy. And we can see that in the judgment of Lord Justice Sachs at page 666, where he, at little c, he starts by, it is convenient, first of all, to deal with the issue of whether, assuming there was a tenancy, the defendant had to pay the rent. So on the basis that there was a tenancy, did the services that were being provided amount to payment of rent? And concludes at page 668H. Even if there was a tenancy, the rent could not apply. At no time there was an agreed monetary quantification of the rent, nor was there an agreed method of quantification, nor was there any statute which provided a substitute for agreed method of quantification. But then goes on at the top of page 669A, I now turn to the task of considering the finding of the County Court judge that the arrangement resulted in a tenancy. And in Lord Justice Sachs's analysis of the evidence, he raised a number of questions at D, basically challenging the extent of the services that were being provided, namely cooking and cleaning, and how. So raising question marks as to whether or not that could give rise to a tenancy, and concluding that it was not a tenancy but a personal license terminable on reasonable notice, since it wasn't a tenancy.
Mr. Colville, I appreciate that he concluded it wasn't a tenancy, but he did decide the rent point. And it seems to me you might get something out of how the reasons he gave for deciding the rent point. That's the critical point for us, I think.
My lady, the reason why I started the way I did was because the decision of the court was this was a personal license, not a tenancy, and therefore the appeal had to be allowed because the judge found it was a tenancy. It's not a tenancy, it was a personal license terminable on reasonable notice. The observations made in respect of whether if it was a tenancy, the question was then whether or not what was the rent that was paid, and whether if there was rent paid, whether that rent could give protection. So
are you submitting that what you call observations was obiter?
Obiter, yes. So I say it doesn't bind this court.
Now this was in 1970.
It is indeed.
Is there anything to suggest that it's been disapproved or not followed in any subsequent case?
No. It's not been, as far as my research has gone.
Hasn't been referred to in any subsequent case?
Not that I'm aware of.
On the assumption though that just for the sake of argument, if you were wrong about it being obiter, and there is a lot of case law, increasing amount of case law on what is obiter and not, it's put observe it's put first as the reasoning. It is a decision on the Rent Act, so the point I was making was, is there anything in the reasoning of Lord Justice Sachs that helps us? Because let's say it is binding,
No.
there is a question of whether it can still be distinguished because it relates to different legislation.
It relates to provisions, yes, that are not. It doesn't relate to the Housing Act. The Housing Act changed the control of private sector tenancies. And whilst there is an overlap in respect of, in terms of protection and exclusions from protection of to tenancies and exclusions from assured tenancies, my lady, the position today, in my submission, whilst it's acknowledged that at common law rent can be provided through provision of services or in money's worth, that for the purposes of translating or interpreting rent for the purposes of the Housing Act 88 is the approach that this court should be adopting.
Right. I mean, just to be a bit more, get into it in a little bit more detail.
My lady, yes.
In his judgment, Lord Justice Sachs refers to two particular aspects of the Rent Act that appear to, he uses to support his conclusion, and they're on pages 69 and 70 of the bundle. The first is in the last full paragraph, talking about the permissible. He says the first relates to the sole permissible method of increasing rents.
Yes.
And the second, which starts in the next paragraph, are
Successors.
sums that are irrecoverable.
Yes.
Now, I'm not sure there are equivalents to those in the current. My point is, he's doing the classic role of statutory interpretation, which is interpreting the provision in the context of the legislation.
Yes.
And he's looking at context to help him interpret the word rent. Is there anything we can draw from that?
Lady, there is provision within the Housing Act 88 for increasing rent. Section 13 of the Housing Act 88 provides that notice can be served to increase the rent. And my submission is that there is the right for a landlord to seek to increase the rent and on service of notice, the tenant can refer the matter to the property tribunal for assessment of what is the rent for the property.
Forgive me if I'm not an expert in the area. The mechanism these days under the Housing Act is designed to ensure that the rent doesn't exceed open market value. Is that?
Well, it's for it to assess what is a reasonable rent for the property.
And that is different.
But the 77 Act had a fair rent,
Yes.
and the fair rent tribunal would assess and demand and control and limit the rent, and it was always suppressed. Whereas the property tribunal can and will look at the rents being that is being charged and whether or not that increase is one that can be imposed. It is similar. There is, I mean, Lord Justice Sachs refers to the Section 3 of the 68 Act, of the 1920 Act, and in the 68 Act, Section 26 for increasing the rent. So there is akin provisions within the Housing Act 88. But what I submit, my lady, is, and my own friend has made submissions on this, but what I submit is that the starting point is to assess the rent for the purposes of determining whether or not the Act protects the tenant, and that is an exercise that can be undertaken by the court when determining whether or not, in this case, there is a claim for possession, and whether or not the Act is engaged. And so when looking at the question of the definition, what is the rent, that is the starting point, is looking at what the parties have agreed to in the contract, what consideration has been given, and whether that how that is to be valued for the purposes of assessing whether the tenancy is protected.
Oh, it seems to me that it's pretty clear, subject to your point about ratio and arbiter, that under the Rent Acts, rent means money. So what I think I would value your help on is whether there is anything fundamentally different about the Housing Act 1988, either because its provisions are materially different or because it's clear that its purpose is different in a relevant way, so that the meaning of rent in the Rent Acts should not be carried over into the Housing Act. That seems to me to be the critical point in the case.
The purpose of the Housing Act 88 was to was to reduce the level of protection that was afforded to tenants, to make it more economically viable for landlords, so that they could agree the rent, and that would be the rent that would be due to be paid. That restriction, the lifting of the restrictions by the 88 Act, swung matters in terms of landlord and tenant in the landlord's favour. So he was able to enter into an agreement free of the knowledge that that was what was agreed and that was the rent that was due, and he would be entitled to recover possession if that rent was not paid. In terms of protection, the scheme mirrors, so far as relevant to this appeal, mirrors that in the 77 Act in terms of exclusions from protection under the 77 Act. But given that the Act,
So the 77 Act, you mean the Protection from Eviction Act, or
no, the Rent Act,
or the prior Rent Act?
the Rent Act 77.
Yep.
Sorry, Lord.
Yep.
So when you say the protections mirror, do you mean the types of
exclusions?
That included if no rent was payable.
Yes, it does.
Do you happen to know the provision in the Rent Acts?
Sorry, Lord.
Do you happen to know the provision in
It's
the Rent Acts?
section 4 and 5.
Don't worry. Okay.
No,
So there was.
follows on from
I think it was referred to in the skeletons that the provision in paragraph 3, Schedule 1, paragraph 3, mirrors a provision in the Rent Acts.
But given that the approach of the Housing Act 88 was to reduce the level of protection afforded and to give landlords more freedom to agree the rent and to agree effectively to enable them to recover then possession because of non-payment and so on, based upon what was agreed. In my submission, a landlord, when agreeing the rent level with the tenant, it must mean and include agreement to pay rent in lieu of through services in lieu of actual monetary payment, because that is if I'm wrong on that, if I'm wrong that that rent means money and only means money, then a landlord can agree to with any tenant that you will pay me through X, whatever X may be, as long as it's not money, and as long as we don't agree what value that X is, then there's no then the landlord avoids the consequences of the Housing Act 88.
But that would have been that would have been the same under the Rent Acts. You were going to say that.
Following if rent is pecuniary.
Yes, well, it is. I mean, if we look to the definition, so your submission would have been the same in. You could have made the same submission
I could make the
in the
same
1980s.
Yes.
prior to the amendments. So if that was the position under the Rent Act, that you weren't protected in that situation, in other words, no money, just services, as my lord was asking you, what is it about the structure, formulation, content, or whatever of the Housing Act that would indicate that Parliament intended to extend protection under the Housing Act to tenants that were not protected under the Rent Act?
My lord, removing the protection, the greater protection that was afforded to tenants under the 77 Act, and reducing that protection to by changing the nature of the tenancy, and the landlord all that he had to do was to serve a Section 21 notice, and provided it's a valid Section 21 notice, and he's able to serve it, then there is an automatic right to possession, and there are automatic routes to obtain possession without. One can do it through the paperwork rather than going to court. Accelerated routes. In my submission, the Parliament would have, in my submission, it must be considered. Must be the definition of rent must include payment in services. Otherwise, it renders. Not only is there a reduction of the rights under the 88 Act, but also there's a clear avenue open to landlords to avoid even the protection that the limited protection that Parliament have enshrined in the 88 Act.
So are you, in another way of putting that submission, is this what you're saying, that the protection is less, and alongside that, there's less need to confine, for the court to confine it, where the protection applies, by interpreting rent in a narrow sense? Is that what you're saying?
I flip it in the sense of because of the reduction, significant reduction in rights to tenants, it must be right that rent is given a wider definition than just pure payment of money. Because to find that it is limited to payment of money, not only has Parliament reduced the rights of tenants under the 88 Act, but left open for landlords to avoid all protection to tenants under the 88 Act, and rendering it effectively academic, because they just have to agree with a tenant that payment is not in money, but in services or provision of gifts or whatever X is. As long as it's not money, and as long as it's not quantifiable, or as long as it's not quantified by the parties, then it means that a landlord can just sidestep the whole statutory scheme, and the Act becomes superfluous.
I mean, in a sense, your argument might have more force in respect to the Rent Act, because you might say the higher the level of protection, the more unlikely it is that Parliament would have created, I think you were calling it an avenue, whereas the lower the level of protection, you might think the less Parliament would be concerned about avenues to avoid that low level of protection.
My lord, I would say it applies more, the level of protection, than less, because the effect of limiting rent to payment of money is to make the Act superfluous.
Now, this is all sort of trying to find some meaning.
Indeed.
I mean, a more direct line is Parliament has used exactly the same phrase.
Yes.
Borrowed it from the Rent Act, taken it from the Rent Act. And well, let's take it that Parliament knew, because that's what the authorities tell us, knew what the meaning was of rents as interpreted by the courts under the Rent Act. So if Parliament really had intended a different interpretation, a different meaning, sorry, in respect of exactly the same phrase, might one not have expected Parliament to make that clear?
My Lord, I would say Parliament could not have intended rent to be limited to pure rent, pure payment of money, because the effect of that would mean that there would be no protection to any tenant, because a landlord can avoid the 88 Act completely.
Thank you.
And that leaves open leaves the position which the unacceptable position which was identified back in Montague, or indeed in Hornby, that the outcome is capable of abuse. And that's why, in my submission, that when interpreting the Act, Parliament could not have intended that level, that abuse by landlords, to remove all protection to all tenants. Looking at it at its extreme, that could not have been the intention of Parliament, given that the common law position is that rent includes payment in services and in kind. So money's worth is rent. My Lord,
I don't know to what extent we're allowed to look at these things, but there's no white paper or pepper and heart parliamentary material which has any bearing on this.
my Lord, I'll be honest, I haven't gone to that depth.
And there was a white paper, because
There
it's
was a white
referred to
paper
in McGraw.
which is referred to by Lord Newberger. I can provide you with a copy of the white paper. That's easy enough. But clearly,
Well,
reading
I don't think there's anything
Woodfall
relevant
and
in it.
Halsbury, there is no reference to it.
No.
So that if there was reference to it, I'm sure it would have been there. My lords,
Yes,
my
thank you.
final point, and I appreciate I've gone.
No,
way
don't
past,
worry.
where I should be.
No.
But my lords, is that if the judge, Her Honour Judge Venn, is correct, and it's accepted that the rent, the services that have been provided can be quantified, so therefore the rent that would be due can be quantified, but does not amount to rent because it's not been quantified, then vulnerable tenants, as I said, are exposed to rogue landlords who can avoid all security by providing accommodation for people who will have to provide services instead of payment, and therefore have no protection or security, which, given their vulnerabilities, in my submission, hence the reason why the concern of the council in terms of modern day slavery, it is a very real issue, and in my submission, this is the opportunity where the courts can, as a matter of policy, decide that actually rent for the purposes of the Housing Act 88 must follow the common law and include rent where payments in lieu of rent through services or gifts or whatever means, and therefore it's for the courts, the county court, to decide and to make inquiries and to consider the evidence to determine what value is to be attributed, and to prevent landlords from seeking to rely upon the absence of agreement as to value between the tenant as to the value of the services provided, which would then fall within the definition of rent. So it must be that rent that is capable of, it must be that services that are capable of being valued can amount to rent for the purposes of occupation.
Thank you.
Unless I can insist any further.
Anything else?
Well, I was just wondering whether the position would be any different under the new Act. I appreciate we're trying to work out what rent means in the 1988 Act, but it will be nice, at any rate, to know the implications of anything we might decide for the law as it will be from a little bit later this year.
Yes. In terms of I'd better not make any submissions in the sense. Can I send a written submission?
Well, do you want to?
Over lunch, can we-
Could you have a quick look at the?
I'm not sure it does, but I'm hesitant to agree that there's. It
Yes.
doesn't.
No,
But
I suspect it doesn't.
Because
as
it's
well.
just changing section 20, the provisions of. Was it just is it just addressing section 21, or does it go broader than that?
it does. It removes the no fault eviction. But,
Yes.
Can I just?
And it adds some new grounds for
It does.
possession, I think.
Can I just check it over?
Yeah,
lunch and
sure.
Come back to you.
Thank
on that
you.
point?
Thank you. Thank you.
No, thank you very much. Yes, Mr. Doyle.
My lords, my lady, would you like me to begin submissions now and then break for lunch?
Yes, please.
Okay, the way I would propose to address you is to address you first on statutory interpretation, as I've set out in my supplementary skeleton arguments. Just to remind you, I have no doubt you're very familiar with the principles of statutory interpretation, so I won't bore you for too long on them, but there are just several points I'd like to make going through those. So I've cited the authorities, the well-known authorities, Quinn Savell, and Secretary of State for the Home Department. I've referred in my. I take it you have my supplementary skeleton.
Yes.
argument.
Thank
So
you.
I've referred to what Lord Bingham said in paragraph 8.
Yes.
So what I would say there is what the court needs to do is to ascertain and give true meaning, give effect to the true meaning of what Parliament said. The second point I draw from that is the task within the permissible bounds of interpretation is to give effect to Parliament's purpose. So you have to read the provisions in the context of looking at the statutes as a whole and in their historical context. That's why I included the MacDonald and MacDonald case. You've already referred to paragraphs 11 to 15 of that, which sets out some of the historical context of the enactment of the Housing Act 1988. One point I would make, my learned friend said, as a matter of policy, the court can decide what rent means under the Housing Act 1988. Of course, it's my submission that matters of policy are for Parliament. What you're looking to do is see what Parliament meant when they used, as my Lord mentioned to my learned friend, when Parliament chose to use the exact same wording in the 1988 Act as they had done in a succession of rent acts, and it's set out at paragraph 23 of my appeal skeleton argument. We'll come on to it. In the context where you were referred to the Protection from Eviction Act 1977, where the Parliament chose in that Act to extend the protections of that Act to tenants where the tenancy was granted for money or money's worth. But in 1988, when enacting the Housing Act, they chose not to do that, but in fact to repeat the exact same wording, which had been used in a succession of rent acts, and where the meaning had been clarified by the courts and had a well-established meaning that it meant pecuniary rent. The third point I take from what Lord Bingham said is it's actually at paragraph 9, which isn't in my skeleton argument, so if I can refer you to it. He refers to something said by Lord Wilberforce. So it's page 11 of the Supplementary Authorities Bundle. That's paragraphs 8 and 9. If I could ask you to read 10 and then over the page.
Sorry, you want us to read?
Sorry, I beg your pardon. This is in the Quinterville case.
Yes.
It's the judgment of Lord Bingham.
Yes.
Paragraph 8 I've set out in my skeleton argument.
Yes.
I'll just refer you to it. Paragraph 9 carries on, so I'd invite you to read paragraphs 9 and 10.
Okay. Yes, thank you.
Thank you, my lord. So, what I would urge the court to be wary of is falling into this trap that Lord Wilberforce guards against by asking the question, what would Parliament have done in this current case, not being one in contemplation? My lord asked my learned friend the question of the pepper and heart point. You haven't been, or nothing's been put before you from Hansard. I did look at Hansard. I couldn't find anything to indicate that Parliament had actually considered whether to change what I'd call the gateway in terms of what I've called the no rent or low rent exception. We don't have the white paper. It's not available online. I'm sure between myself and my learned friend we can get hold of it if that would assist the court. At least some of the material points from that white paper are set out in the judgments of MacDonald and MacDonald at paragraphs 11 to 15, to which you've been referred. And the point I would make there, and I think your lordships and your ladyship have already grasped the point, but really the context of the enactment of the 88 Act was deregulation. So the point made in the white paper is that letting private accommodation had become an uneconomical proposition for landlords because of the very high levels of protection under the Rent Act and the rent controls and so on. So the 88 Act, what Lord Bingham says in Quinterville is any enactment not being consolidating legislation is solving a problem, effectively. It's designed to correct mischief. The mischief that it's seeking to correct isn't the problem that the appellant finds herself in this case, and there's nothing before you to indicate that actually Parliament intended to change that position whatsoever. Hence, I say, using the exact same language that they had done in the succession of Rent Acts before it, not adopting the definition you've been referred to in the Law of Property Act 1925, not using the phraseology that was adopted in the Protection from Eviction Act 1977. And I say, for the reasons I'll set out, as a matter of interpretation, there's nothing to persuade the court that Parliament meant anything different in the 1988 Act than it had done in the succession of Rent Acts before it. Or, alternatively, to depart from the normal grammatical meaning of rent. I'm about to address you on the principles which I say are relevant from Bennion. So I'd ask the court to have those principles in mind. Paragraph 3 of my supplementary skeleton argument, I've set out the well-known passage from Lord Hodge in our own Secretary of State at paragraph 29. Could I invite your lordships and your ladyship to read that paragraph?
I think we have read that, so thank
Fine.
you.
So the point, the main point I draw out of that is the primacy of the language. So towards the bottom of the paragraph, the words that Parliament has chosen to enact as an expression of the purpose of the legislation are therefore the primary source by which meaning is ascertained. There's an important constitutional reason for having regard primarily to the statutory context. As Lord Nichols explained in Spath Home, citizens, with the assistance of their advisers, are intended to be able to understand parliamentary enactments so that they can regulate their conduct accordingly. They should be able to rely on what they read in an Act of Parliament. The point there, which I'm going to make, is that rent as a normal word in the English language, the normal meaning of it is payment of money, usually periodical payment of money. That's how citizens would typically interpret it. The fact that the parties in this case may unusually have termed it something else, i.e. rent, in the agreement, is not good reason to extend the meaning beyond the well-established meaning that had been set out in the succession of cases under the Rent Act, or beyond the usual grammatical meaning which ordinary citizens would have of the word rent.
Well, if you're looking at ordinary grammatical meaning and you were simply construing the contract, you wouldn't think there was anything wrong with the heading rent and the provision for work to be done.
My lord,
would you? And indeed, if you happen to know about the common law, then you'd be absolutely right. It's only if you know about the Rent Acts, that a different result obtains, isn't it?
Well, my lord, I say it goes the other way. I say the normal grammatical meaning of rent is not actually is different from what these parties have labelled it as. I'm going to go on and address you. There's a passage in Woodfall which says the label attached by the parties is not determinative, i.e. just the fact that the parties have called it rent doesn't make it rent as a matter of law. The other point is, my lord, rent in the common law meaning of rent and the specific meaning of rent in the statutory context under the Rent Acts and the Housing Act are different, because under the Rent Acts and the Housing Act, rent is obviously a gateway or threshold, I would term it. You have to be paying rent and above a certain level, but below £100,000 a year to get the statutory protection of the Rent Act or afterwards the Housing Act, which confers various benefits. The Rent Act it conferred the benefits of controlled rent, so often people under Rent Act tenancies were paying well below the market rent. Under the Housing Act, you get security of tenure, and the landlord can only evict on various grounds and various other protections. So the statutory meaning, I say, of rent is a different matter from the common law. That was established by the Rent Act authorities and as a meaning of normal statutory interpretation. So I don't know if you want me to go through, and I've set out my skeleton argument at paragraph 4, the relevant principles I say that can be drawn from Benny and Bailey and Norbury on statutory interpretation. So plainly reading the text of the enactment in context, looking at the statute as a whole, but also in its historical context, to which you've been referred from MacDonald and MacDonald. 11.4, the presumption that the grammatical meaning of the enactment, i.e. that which is arrived at without taking into account legal considerations, is the meaning intended by the legislator. Reading the Act as a whole, I've already said. The presumption that the same words being used more than once have the same meaning. I'll come on to that because there are numerous references in the Housing Act 1988 to rent being payable or unpaid. And that word, my lord mentioned several times the use of the word sum or amount, due, or payable and paid. All of these words, as a matter of natural meaning, lend themselves to the interpretation that I say Parliament intended, that rent have its normal grammatical meaning, or perhaps the slightly more nuanced meaning as given in the Rent Acts. And then 24.5 and 24.6, these go to the Barras principle. So where an act uses a word or phrase that's been the subject of previous judicial interpretation in the same or similar context, it may be possible to infer the legislature intended the word or phrase to bear the same meaning as it had in that context. I've included all of those extracts from Benny in the authorities bundle. Do you wish me to take you to them?
Well, is there anything that you say that they contain that we need to see?
Well, probably. So if you can turn to page 101 of the supplementary authorities bundle.
Yes.
So this is the Barras principle. This is why I say effectively you should follow, albeit the Rent Act and the Housing Act, the Rent Acts and the Housing Act are not the same, given that the threshold or gateway uses the same words in terms of rent payable. I do say it's highly persuasive.
Just for my benefit,
Yes.
when you say the same words,
Yes.
was that the 2/3 of rateable value?
So,
Or was there a similar numerical?
my lady, can I refer you to my main appeal skeleton argument?
Yes.
It's paragraph 23.
Yes.
So I've set out there the sort of historical developments of the provision. So
Yes,
it starts
so
off.
all refers to 2/3 of rateable value.
Yes, and initially, the paragraph 3 and 3A of the Housing Act did as well. If you look at footnote 5, no, sorry, if you look at my paragraph 23D,
Yes. And then it got changed. Yes, I was slightly intrigued by this.
yes,
It
so
got changed by regulations.
it did because there was the move away from rateable values in 1990. Rateable values for domestic premises were got rid of, and council tax was introduced in their place. You still have non-domestic rates, obviously, for business premises, but there was a move for domestic premises away from rateable values. So Parliament inserted in by way of these 1990 regulations.
So, from my bit, those regulations were presumably made pursuant to the legislation that introduced council tax,
I would guess so.
rather than, for example, always being an intended change under the Housing Act.
I'm very happy to look that up and
Yeah.
put written submissions, but that would be my guess. Yes.
Okay, so you say that when in trying to understand what was in the mind of Parliament, as it were, when it introduced the 88 Act,
It was exactly
simply 2/3 of
exactly.
rateable
It was
value.
exactly the same as it had been under the Rent Act 1977. The change in wording was introduced in my footnote 5 by the references to rating brackets housing regulations 1990. So that was a subsequent change, unlikely to assist the court in determining the intention of Parliament in 1988. And that was simply a consequence of the move away from rateable values. So I say that I call it the phraseology I'm using is a threshold or gateway, paying a certain amount of rent to get yourself the protection of the Rent Act and then subsequently the Housing Act 1988.
You were taking us to
Yes, Benny, and I was page 101. Can I just invite your lordships and your ladyship to read the first few paragraphs? It's just the principle and then examples where, in a similar context, previous judicial interpretation has been adopted.
which one? Where do you say we are? Because it if you look at Lord Lloyd, long be a rule of construction that when Parliament uses a word or term, the meaning of which has been the subject of judicial ruling in the same or similar context, presumed, and then Lord Hodge reenacts. Are we in a reenactment or are we in a similar, same or similar context?
I think it's probably same or similar context because the Housing Act is materially different from the Rent Act.
And the statutory provision that you're excluded if no rent is payable is a reenactment
That is a
of the same provision,
Correct.
but in a different context.
Slightly different, yes.
Yes.
I mean, the Housing Act 1988 was designed to, and does expressly by provision, phase out Rent Act tenancies. It was designed to effectively move away from the tight controls under the Rent Act and introduce, as I think my learned friend's already said, this scheme of assured and assured shorthold tenancies.
I mean, in part it amended the Rent Act, didn't it?
I beg your pardon?
In part it amended the Rent Act.
Yes.
So it has different provisions within it, some of which we might say are freestanding, some of which sort of tack on bits to the Rent Acts, and some of which just amend them.
Yes, I mean the Housing Act 1988 is a very long statute with many provisions. It did. I mean, now one sees very few rent-out tenancies, obviously because it's so long ago, and the rent-out tenancies had provisions for succession by family members and so on, but they are slowly dying out, or they have been slowly dying out since the 88 Act was enacted. But I mean, in a sense, it was a piece of replacement legislation, I suppose. But yes, my lord, I can't give a conclusive definite answer to that. I think it probably falls somewhere between the two. I mean, it seems to me that what Bennion says about it is the latter, which you've referred to, Lord Hodge saying Parliament reenacting. It says rather than giving rise to a presumption that the legislators approved or adopted the meaning, it's simply part of the legislative history and legal context. So it probably waters down slightly the status to which you give the earlier rulings. But for the avoidance of doubt, I'm not saying that the Rent Act cases are binding on you, for example, because it's a different statute. I'm just saying that they're highly persuasive authorities in the context where Parliament has chosen to use exactly the same wording that it had done under the Rent Act.
Yes, thank you.
On that point, is it convenient to address you on the Rent Act authorities now?
Yes.
So you've already been taken to. So there are effectively 3 or possibly 4, and I'll explain that. There's Hornsby and Maynard, which is the 1925 one. That is the one that interpreted the increase in mortgages restrictions Act 1920, and that was the starting point, which said that rent is monetary rent, effectively. And then you've been referred to Montague and Browning, which was the 1954 case.
Is there any part of Hornsby that you want to take us to?
It's referred to in the latter authorities,
Okay.
my lord. So I'm not sure
Thank
I really
you.
need to.
So Montague.
Montague, you've already been referred to the material provisions. I mean, my lord made a very astute observation, which is that Lord Justice Singleton and Lord Justice Morris said that actually Hornsby and Maynard didn't weigh on that case at all because it was a different set of facts. In Montague and Browning, you have an agreed rent and an agreed value of the services provided. So, do you want me to take your lordships and your ladyship to the authority?
Okay.
I don't need to. You I got the sense you were looking for it. It's on page. Yeah, 51 of the authorities bundle.
I mean, is there any? As you say, we have looked at it.
Yes, you've looked at it already. No, all I was proposing to say is it's a different set of facts, and the 2 of the judgments of those of Lord Justice Singleton and Lord Justice Morris deal with it as just being. It's right to say there is some criticism of Hornsby and Maynard, but effectively they're saying this is a case where the value of the rent is agreed, the value of the services are initially agreed, and then the value of the services are increased such that they cover the entirety of the rent, and so Hornsby and Maynard was of no applicability. Barnes and Barrett, you were then taken to that. That's at page 59 of the bundle. So, my learned friend, I think, made the submission in relation to Barnes and Barrett that the observations in relation to the meaning of rent were obiter. There is a subsequent authority that follows Barnes and Barrett on that point, so in my submission, that submission cannot be right. That case is Bostock and Bryant, which is at page 163 of the authorities bundle.
Yes.
So, on page 164, the second point of the summary of the judgment. The matter was covered by the decision in Barnes and Barrett. And then the judgment of Lord Justice Stuart Smith.
Sorry, could you just say, what was the agreement in this?
This was a case where there were services provided. It was a sharing arrangement essentially. The facts are set out. If you look at page 163,
Yes.
there's a summary of the facts. So the tenants paid the gas and electricity bills. They carried out repairs to the house, and I think they did some cooking or cleaning. They provided other services to the landlord. I should just point out in relation to this case. No, in fact, it's Barnes and Barrett. No, I beg your pardon, my lord. The facts of this case are slightly different. This is, you'll recall my learned friend made this submission, which your lordships and your ladyship identified as being a new point.
Yes.
About the services.
Yes.
So this case, Bostock and Bryant, actually has dual relevance to the court. I say it's germane to that point, at least in relation to the Rent Act. So they say in this case that payment by the tenant to services constitute rent, and they also follow Barnes and Barrett. So I say you can be satisfied that Barnes and Barrett is good law, and that the findings in Barnes and Barrett in relation to the Rent Act and the meaning of rent was ratio and not overture. If you want the reference in the judgment,
Please.
of Lord Justice Stuart Smith. It's on page 169. The third or the fourth paragraph. In my judgment, that case does not assist the defendants here, as I've already indicated in my judgment, where the payment is not specifically designated as rent and does not appear to be the payment of a sum in respect to rent. The court can only reach the conclusion that it is rent if that's the proper inference to draw from all the circumstances of the case. That's payments made in respect of utilities or services. And he then says, for those two reasons, that in my judgment the matter is covered by the decision in Barnes and Barrett, I beg your pardon.
Yes.
The references to Barnes and Barrett, they set out quite lengthy sections of the judgment in pages. So the first reference, there's reference to a submission made by Mr. Hodgson, who was presumably counsel in that case, at the bottom of page 166. So the submission made is the effect of that case is that so far as the Rent Acts are concerned, and we are dealing here with a Rent Act case, rent has to be a payment in money terms and not in the satisfaction of bills, which may vary from time to time. Then there's quite lengthy citation of the passages from Barnes and Barrett. Then towards the bottom of 168, it says, Mr. Hodgson says, with force, it seems to us that those observations apply equally in this case.
Where was that?
Towards the bottom of 168, 2 paragraphs up from the bottom.
Oh.
I'm sorry, I don't wish to rush your lordships or your ladyship if you,
No, it's
want
right.
to take time to read the passages from, I think you've already been probably referred to the passages from Barnes and Barrett.
We have. Yes.
So I say that you can be satisfied from Bostock and Bryant that in 1990, when that case was decided, Barnes and Barrett decided in 1970 was still considered to be good law in relation to the Rent Acts. I appreciate, my lords, my lady, it is a slightly different, the Rent Acts are not exactly the same as the Housing Act, but the fact of the similarity of the provisions and the similarity of the context, I say, gives good justification for following that Parliament, who, as my lord said, must be taken to have known about the interpretation of rent that the courts had given. So by 1988, the first case, Hornsby and Maynard, was in 1925, so that decision had been around for 63 years. The only departure from it had been in Montague and Browning on a case of very different facts to the other cases, and indeed to this case, where the value of the rent was defined and the value of the services were defined. In this case, the value of the rent and the value of the services align, but there's no quantification by the parties, no attempt to quantify either.
Well, more simply, in Montague, some members of the court said that Hornsby and Maynard might need to be looked at again, and in Barrett, Barnes and Barrett, it was looked at again and was Hornsby right.
Yes, quite. So, and then again in Bostock and Bryant in 1990, where it was followed, if not expressly approved. So Barnes and Barrett is good law. Montague and Browning decided on very different sets of facts and not followed in Barnes and Barrett. So in terms of the effect of the Rent Act cases, the position's very clear. If you had been deciding this under the Rent Act, in my submission, there'd be very little scope for argument at all. It's only the fact that this is under the Housing Act 1988, and there's no known reported authority on the meaning of rent under the Housing Act 1988 that has led the parties to this court. But in my submission, for the reasons I've given, there's no reason for the court to depart from that interpretation that had been given in the Rent Act.
Should we? How much longer have you got? Not seeking to rush you or anything, just an inquiry.
Yeah, I'll probably be a little while longer.
Okay, so we'll stop now and start again at 2 o'clock.
Thank you.
Court rise if able. That's all right.